Well, good afternoon, everybody, or good morning, depending on what time zone you're in. Thank you all for being here today for our second part of our webinar series, Who Will Fill My Shoes? Succession Planning for Landowners, Farmers, Forest Owners, and Family Businesses. This is week 2, and we'll be talking about legal and business structures. So, again, thanks for everybody being in attendance today. If you weren't able to make it last week, no worries. All of these are recorded. So, at the end of today's session, I will email everybody out the website where you can download all of these classroom materials, PowerPoint, and you'll also have access to last week's recorded video. And it takes us a couple of days, and then you'll have access to today's recorded video. The material that you are seeing today is based upon the work that is supported by the National Institute of Food and Agriculture and the U.S. Department of Agriculture. Any opinions, findings, conclusions, or recommendations expressed in this publication and this webinar today are those of the authors and do not necessarily reflect the view of the U.S. Department of Agriculture. Throughout today's webinar, feel free to add any questions or comments into the chat. At the very end, we will review those with the presenters today. And then at the very, very end, I do have a survey that I would ask for you to take for us and kind of give us your feedback so that way we can always continue to evolve and make these webinars a little bit better for everybody. So with that, we have two presenters with us today. Dr. Kurt Smith is the Assistant Professor of Forestry and Environmental Resources at North Carolina State University, and Dr. Rebecca Smith, she's Associate Extension Professor at Mississippi State University Extension. So I'm going to pass it over to Dr. Kurt Smith to get us started for today. Thanks.
All right. Well, thank you, Roseanne. Thanks for the introduction. So today we're going to get into probably a little more of a little meatier if you were following along last week. This is going to get into legal and business structure. So it's the kind of topic that a lot of you want to hear and some of you don't, but we're going to wade through it. What I tell a lot of forest owners is you really have to pay attention to the frame, not the picture. And what I mean by that is in forestry, you can do anything you want with your land, and in agriculture and farming as well. I can plant soybeans, pine, oak, whatever. It's a blank canvas, but what you need is a frame to hold it up. And in this case, that frame is the legal architecture. Otherwise, your farm, your forest is sort of at threat. So pay attention to the frame, I guess, is my admonishment to landowners that might be listening to this, or one that you might make if you're a presenter. So partnering organizations, this is the slide. Obviously, I'm from NC State, and all the funding and help for this has come through the SRDC, also through North Central Regional Center for Rural Development, Purdue University, where Renee is at, who also helped author a lot of the material, the Institute for Family Business, as well as Mississippi State's Department of Agricultural Economics. So with that, I want to talk, some of these slides are sort of setups, I guess, that we're doing at the beginning of all of these presentations, just to make people aware of the purpose and a few definitional things as well, so that we're all sort of thinking along the same line, if you will. So succession planning really encompasses a lot of those sort of family, emotional thinking type aspects to running a family, to involving your family in your business and transitioning it forward for the next generation. So I differentiate a little bit from estate planning, and we'll talk more about that pretty quickly. So people just absolutely live longer now. So 20 or 30 years ago, people would work and they would pass on their estate when they hit 70 or 80, and they probably didn't live much after that. But now people are retiring at 60, 65 years old, and they're going to live for another 20 or 30 years. So enter the idea of succession planning, trying to get your business or your land moving forward, probably still producing income for you, probably helping to select an heir that will run the business, farm, forest in a way consistent with your objectives. So that's kind of the difference between it. All right, keep rolling here. So I think this is always the disclaimer I think you want to make when you're in extension or you're doing any public speaking, and doubly so if you're talking about legal things. We're doing this strictly as an education piece. I think everybody knows that. At the end of the day, what we're trying to do is to point people to go in smart, to go in educated, to go in knowledgeable when they see their attorney, when they go in to see their CPA. So this is strictly educational. It's almost impossible to give advice because everyone's circumstance is so utterly different. Everybody's goal, everybody's priority. So typically, most workshops begin by sort of the admonishment of no personal stories. General questions are welcome, and if you have personal questions, to ask outside the group. I will throw in or offer that with some minority land groups, storytelling is part of what they do. So you sort of have to use your best judgment on how to control that to keep it time constraints reasonable, not getting off track when you present this stuff. So new definitions. When we talk about succession planning, what are we talking about? We're talking about that transfer of management and even ownership while I'm still alive. I'm picking out my successor. I am possibly even transferring my property to somebody and maybe getting a percentage of the income for the next 20 years while my son or a business associate takes over. Estate planning is a little different. Typically, this is the types of things, the legal architecture that you need to put together to transfer your assets and property after you're gone, that thing that nobody likes to think about. So that's a little bit of the differentiation. And you can tell just from that dichotomy that succession planning is a lot more human, right? A lot more dealing with family, friends, money, that kind of stuff while you're alive. We're going to use the term throughout these presentations, these 5 modules, successor and incumbent. So when we use the term successor, we're talking about that next generation that will come in and manage the land or own the farm or business. When we use the term incumbent, we're talking about that next generation, that senior generation that now currently owns the property and is making those decisions. Well, 2 more terms we'll use are businesses and land. I think these things are really self-evident, but we felt like it was good to keep definitions in front of us before we dive into material. But businesses could be anything from farms, a family forestry operation, an LLC, sole proprietorship, land in a trust, corporation, etc. Land, when we talk about it, is anything. Bare land, vacant land, assets that you own as a landowner, could be absolutely anything, along with pastures, buildings, barns, etc., etc. So real tangible property. So we're going to talk today, we're going to explore a little bit about intestate title, if that's a new term for you, some of the tools to remediate and prevent that, and some of the problems that have occurred from having intestate title, that is, not having anybody with clear ownership on the title. We're going to talk about transfer options for your property today, a little bit about ownership structure and transfer. So the different ways that you can own property in your business, and then some of the different mechanisms and legal architecture that you can use to transfer your real property and assets after you're gone. And then a little bit, and Becky will hit a lot on this, some of the steps and some of the tools that we'll give on what you need to do before you go visit professional advisors. So part of the premise, I think, for that section that Becky's going to cover is that, you know, lawyers work for $300-400 an hour and CPAs $90-100 an hour. Of course, I'm in the South. In the Northeast, it's probably double that. But you want to go in there knowledgeable. You don't want to go in there and spend an extra 10 hours or $4,000 covering material that you can simply educate yourself with before you go. So we're going to start out talking a little bit about intestate title and how that works. So it's sort of noteworthy to know too, that why is this such a timely topic? 40% of our farms and forests and agricultural lands are owned by people that are 65 and older. It's almost 370 million acres. And so we're getting ready to have this massive transfer of land throughout the United States. And that'll cause a lot of fragmentation of property, which is problematic for forestry, which is problematic for farms. It's problematic for hanging on to our prime agricultural soils. So we don't want that as we undergo the biggest intergenerational transfer of wealth, probably in history. And when you add to that age, when we work with landowners, we talk 90%, a recent Harris poll pointed out 90% of landowners intend to pass on their assets, their land, their property to heirs. But 40% of these folks 65 and older have no will, no trust, no provision for after they die. So there's a big disconnect there and really kind of a catastrophe waiting to happen, but one that can be remedied through education, through outreach, and through the creation of good legal architecture. The other important part about estate planning and succession planning to point out here is, and this is sort of anecdotal, but it's really true. If you're like me, I'm not particularly concerned about my assets and money after I die. I'm concerned about was my family going to get along. And so I've probably worked with 1,000 different families, and the most heart-wrenching thing to see is families that love each other and get along well fall apart when it comes to this. Mom and dad die and they don't have a will in place. And suddenly siblings who love each other and care about each other and get along well suddenly don't speak for the rest of their lives, and the property gets sold and broken up. And that's really the heartbreaking part, I think, of this succession and lack of estate planning. So what does this lead to? This sort of dying without a will, which is what dying intestate means. You die without a will. It's created a lot of problems in the past. And I think a lot of the folks listening to this have undergone heirs property training and know a lot about that, right? So the trigger for that, the beginning point of that, is dying without a will, which for African Americans is a perfectly plausible reason. You're afraid, you don't have money, you don't understand the legal system for 100 years. But so we do have this past, which has led to theft, fraud. We have Supreme Court cases that have ruled USDA has done, it's been problematic to get equal access for all minority land farmers. And it's also created a huge loss of intergenerational wealth. So in the case of African Americans, 90% of African American land has been lost in the last 1910 to 1990. That's breathtaking. But the worst part of that is that loss of intergenerational wealth. So a lot of us get our wealth because we inherit. We get money passing forward. When that's gone, you're kind of like starting to race 10 feet back. So what does that mean statistically? One study has the average white farmer landowner, their median inheritance per family member is $104,000 versus an African American family, it's only $4,000. And a lot of that is being divested over a long time. And a very similar story for Native Americans, but it's a similar story for everybody, right? So if you die intestate without a will, you're sort of the genesis of new heirs property, regardless of what class you're in. So some of the present problems are partitioning, which a lot of you probably that have gone through the heirs training know a great deal about. So I won't dwell on any of that, but this loss of intergenerational wealth, this loss of prime agricultural land is one of the big problems. Towards the future, this is only going to continue. My state is number 2 in the country, North Carolina, for land loss, losing 1.2 million acres by 2040, a staggering amount of property. And the United States population by 2050 will be 500 million people. So where are these people going to go? They're going to have new developments, new roads. Where does that happen? It goes into farms, forests, agricultural land, greater fragmentation. And so all of these are really compelling reasons, I think, to help keep the family forest and farm together. And you, as workshop educators, providers, you're in a unique position to help families position themselves to sort of get a leg up on this. So what are some of the common triggers that people have that cause them to want to get succession and estate plans? If you remember when I mentioned a little earlier, 40% of these folks that are 65 and older have made no plan, have made no provision for after they die. Some of them hold thousands of acres. And the typical comment is, well, I'm sure my kids will do right. That's not the kind of approach you necessarily want to take for success. So what are some of the triggers that make people go out, seek an attorney, start thinking about my assets and what I'm going to do going forward? Well, the first one is marriage or divorce, right? So the presence or absence of a spouse can have a big impact in how your estate is eventually divided. So those are going to vary by state as well. Children and adoption. As you have more children or you adopt children or get stepchildren, this is going to impact the way you want to divide your estate. That's often a trigger for people to get involved. Sometimes the buying or selling of a home will cause people to go see an attorney and get involved in estate planning. And then also your finances. Often we come into new money. Often we come into a large 401k, maybe through inheritance. So new financial accounts. That's another reason that drives people to see attorneys, to get wills, to set up trusts. Often starting a business or selling a business, either one, can make people address those changes. Moving to another state is another one. All laws are very different state by state in terms of how they're set up and in terms of how estates are settled. So that would naturally cause somebody to consult an attorney. If I moved from New York and I live now living in California, for example. So obviously some of the big ones that trigger people to go as well are death. So somebody in your family dies, so you need to adjust whatever you were planning for your business, whatever you were planning for your estate. And believe it or not, the number one trigger, I was reading an article, the number one trigger to make people go and get a will and get an estate planned is a diagnosis, a medical diagnosis of cancer or heart disease is the number one reason that will drive people to make changes. So there's a whole lot of reasons for sending people to do that. Well, what about transfer options? So there are as many options as you can imagine for moving your business forward or moving your property forward while you're alive or while you're dead. And a lot of people know a little bit about each of them, but not usually a lot about all of them. And it's good to be educated. It's good to educate your clients, your folks, so when they go to an attorney, they have some idea of what they're talking about and what they're asking about. So here are some common transferring mechanisms for your land. So obviously you can, somebody can just sell their land, liquidate their assets. So this removes all decisions from the heirs. So maybe they just want to go tour the world or whatever. You can liquidate your property, your farm, your forest. Another possibility that sometimes will happen, if no heirs are interested, and this happens a lot in my state, as they have kids that are interested in technology, they hate the farm, they hate the forest, they know there's no heir that will keep my legacy going. Some folks will pursue donating their land, and they'll find a land trust that's consistent with their objectives, and they'll make that donation. Some people will just select one successor, and this is not that uncommon. I have 3 sons. There's one son that wants to do the farm and forest. So I will will it to him, and maybe I'll give the other kids the 401ks or just it's been great knowing you. So you just pick one successor. Another one is to divide among successors with a trust or will. And that would usually involves making clear who gets what via division. So if it's a 100-acre farm, it can be a 10% interest or 10 acres out of 100. So you can specify that. Or another option is you could leave it undivided. And if you leave it undivided, that's dangerous for one thing, because essentially the way the law reads is 100% of the heirs have access and run and a say on 100% of the property. So it requires an incredible amount of cooperation. This is the one that often will lead to family disputes. And then, of course, there is the do nothing option, which, believe it or not, happens. And what happens there is if the heirs want to get their share, they have to go to court and probate it. And each state has almost a recipe book for how they're going to divide it out between heirs, spouses, et cetera, which may not be to either the person that is willing the property or business. It may not be to their liking, and it may not be to the heirs' liking, but the judge will simply follow it and dispense of their things. So really quick, and I've kind of walked through it a little bit, so I'm going to breeze through these pretty quick. You can obviously just sell your land, right? A lot of landowners will sell their land because they're tired of farming. I don't have a kid that'll do it. And they might put that land into or the money from that into some sort of fund, a 401k, some sort of investment fund, and then they can live off that interest and they can deal with it as they want. Some people, another mechanism that's become a little bit popular, it is not a perfect tool, but you could look it up, or you could encourage people to study this with their attorney. It's not right for everybody, but it's called a transfer of deed on death, or a TOD. And it's a simple way to go record in the deed that your heir is actually named on the deed, but he doesn't assume the property until you're dead. So what that does, the big plus to doing that is you don't go to probate court. So when I breathe my last breath, that land becomes my son. You don't probate at all. And so there's a big advantage to doing that. In some urban areas, probating can take 2 years to go through. In the meantime, your heir has to pay the taxes, do the maintenance, and they can't sell it. It's locked down for 2 years. So for some people, doing a TOD makes a lot of sense. One of the downsides, though, of doing a TOD is you also are assuming the liability. So if I were somebody, my dad put me on a TOD, but he also rang up a ton of debt, and he was $1 million in the hole, I would assume his liability. So that's one of the reasons to work with an attorney and know what you're doing. So these are some of the states listed here. You may see your state on here where TODs are allowed. They all have a little nuance to them. So again, the admonishment, which you'll hear over and over again, for me at least, you need to talk to your attorney or tax specialist to understand the law in your individual state. There's also a really beautiful mechanism, in my opinion. There's also several states that have what they call ladybird deeds or enhanced life estates. So they're very much like TODs, but the person that actually has the ladybird deed has complete control of the property. I can back out from my beneficiaries and sell it, decide I want to go on a Viking cruise for the next 30 years. Whatever I want to do, they can't say anything about it. And they can't come back on me when that property passes to me, because I had a lot of medical bills and stuff like that. So the heir is protected from a lot of stuff. It's like the best of both worlds, right? But not very many states have those. And I've listed the ones that I know have ladybird deeds or an enhanced life estate: Florida, Michigan, Texas, Vermont, North Carolina, and West Virginia. So as I highlighted, the big risks are you're taking on the encumbrances, any liens on the property if you get listed on a TOD. The positives are you are avoiding that probate process and the expense in having your property locked down. So see an attorney, figure out if that's a mechanism for your clients or for your folks to look at, right? Donation of land is a great thing, but again, it's not something where I want to go find the Happy Valley Land Trust and give it to them. You want to work with a tax attorney because when it gets into donation, you're getting into taxes, gift amounts, which might need to be spread out over a number of years, and also the terms of the donation. So all of this to say you need to continue to work with an attorney even if you're giving your land away, or you could put yourself in a tax position that you don't want to be in. All right, so selecting one successor is a great way to go for some. If you find somebody that's truly interested in the property, you simply include them in the will or possibly a trust as a single successor. This is a nice tool. Selecting a successor early for your farm, for your forest, for your ag land could give you a window of 10 or 20 years to train them. And when I mean train them, kind of groom them to let them to know what your wishes, your goals are, teach them some of the stuff you've learned, prevent them from making some of the same mistakes. They'll know who to work with as a tax person, an attorney, a forester, a soil scientist. They'll learn the tricks of the trade. So selecting one successor is certainly a good way to go, as opposed to leaving the land undivided to all successors, which is a kind of a dangerous way to go. So if you're presenting to a group, you don't want to be too prescriptive because this can work. You could have a tenancy in common agreement. It's not a perfect tool either, as we'll talk about that briefly, but an undivided interest is a prescription for disaster for families typically. And I talk to a number of those on a pretty regular basis. So I think we've kind of hit that slide for the most part. I did mention, so in some cases, it's just irresolvable. Maybe the thing has already happened. It's already been passed on as an undivided interest. So the next best thing, if there's 1,000 heirs or 100 heirs or 50 heirs, or you can't agree on anything, is the next best thing is to try to form a tenants in common agreement where everybody gets on the same page, or perhaps an LLC where everybody's protected from liability, from being sued, where everybody has to agree to do an action or a trust. So there's some tools you can employ without just getting a single successor or necessarily having a clean or untangled title with one owner. All right, so I'm going to keep moving here. So the other is the do nothing option, and I think I mentioned that as well. You're essentially going to follow the state law. You're going to follow what a judge says. So when I do this workshop in North Carolina, I have a slide that shows the prescription from North Carolina. If you're doing this workshop, it's very easy to find. You could probably find a slide or a tile that is a prescription for how the judge will probate when no will is in place. And it's very specific, spouse, divorce, death, no parent, one parent. It's like a cookie book. So it tells you exactly what they'll do. And of course, the judge has some discretion as well. But that's typically not a good way to go. All right, so we're going to move on a little bit. And I hope this isn't too much like drinking from a fire hose from everybody. But the good news is all of this stuff is available to you to look at again. And it's also available in these books. Becky's going to point you to some publications that you can download and keep. They're going to explain all of these categories and groups that I've been talking about, so you can refer back to those. So think of this as kind of a first pass at all this material. And I encourage you to look at it better, particularly if you're one that's planning to present the material. So 2 groups of ownership for transfer of land or businesses during life and after by survivors. So the first requires you really to do nothing. I don't really necessarily have to see a lawyer or do anything. I can set up sole ownership. I just own the land and I'll do whatever I want with it. There's no great communication piece that has to happen. I don't have to set anything up really. The second one is joint ownership with right to survivorship. And what that means is if I'm in a farm or a business with a business partner, a friend, we're in it together. And if my partner dies, I just assume his share of the business. It doesn't transfer. And so it keeps going until there's just one partner left and they have the entire property. So it's everybody's rights are extinguished as they die. And the last one is tenancy in common, which is the prescription for a mess, because this will transfer via blood relatives et cetera, et cetera. This is the one where you can accumulate 10, 20, 40, 50 heirs if it's unchecked and not sort of managed. So group 2 here, this requires a little bit of legal architecture. And we'll talk about these three: forming a general partnership, limited partnerships, limited liability corporations or LLCs, and then S and C corporations. Most people are in the S corporation world, but there can be both. And then forming trusts. So these are things you're going to almost surely involve a lawyer in. You're almost surely going to have to talk to family members, and you're going to have to do some hard thinking and make some choices. All of them, and the big takeaway from this is they all have differences with distinctions for management, for taxes, and for legal liability. And so selecting those requires sort of very personalized thought, which you want to think about even before you go to see an attorney. So we'll kind of breeze through these pretty quick, and then we'll kick it over to Becky here in another dozen slides or so. But sole ownership, just where one individual holds the legal title.
You muted yourself.
Or you went to mute for somehow.
How long has that been going on? Have I been
Just
on
since this slide. Just
Really?
happened.
Did it just
Yeah,
happen?
just happened. You're good. Keep.
I apologize if I did that. I'm gonna blame it on you since I'm talking. So maybe Becky did that to me. I don't know. So sole ownership, yeah, we talked about that a little bit. So I'll press on. So joint ownership, we talked about this too. We're essentially, as your co-owners in your business or farm die, the others automatically get your share of the ownership until there's one left standing, so to speak. This is not an uncommon practice in some operations. A lot of medical practices and businesses like that kind of follow that pattern. Tenancy in common. These interests can be transferred via a will, and they go to probate. If they don't go to probate, then they ultimately are you're growing your number of heirs, right? Owners can force a sale or sell the interest without consent from the other owners. So that's problematic. So tenancy in commons, if I had to characterize it in general, I'd say it's a good thing to have an agreement like that just to force conversation among the owners themselves, among your family. All right, so after death, God forbid we're going to die. I don't plan to die, so I don't know about you. But if it happens, my dad's 101, so I figure I'm on a roll. But different business structures that you can pursue here, right? General partnership, where you have two people and they have this for-profit entity. The partnership will file a tax form in addition to your individual taxation. So in a way, it's a little bit like double taxation, right? So your business, you're going to pay business taxes, and you're going to pay your regular taxes, your regular income. So there are some issues with that, but there are also some benefits in terms of liability. No formal agreements are necessary for this ownership. It can be a written agreement between two parties, but you really should have a written agreement to define the management structure, who does what, and what percentage of share each person has. And if we have to buy and sell, how are we going to do it, right? So general partnerships. Then we move on to limited partnerships, which is another option. Really only differs and it offers some limited liability to some of the partners. So I can be a partner that's not a full partner, just a limited partnership, a 40% partner. The other guy's 60, I'm a limited partner. So I don't assume personal liability. And that'll pop up a little more when I talk about LLCs. So if I screw up and do something and get sued for $1 million, I'm a limited partner. I may have some liability protection, whereas the main partner, general partner, would not. So that's a positive thing. These can end with the death of a general partner. but they can also be written into wills and agreements, et cetera, et cetera. So this is the one most people ask me about. This is like the candy. Everybody wants to, let me form an LLC. You can form an LLC for, in most states, $200 to file, and you do a small report once a year. And these are wonderful structures, wonderful legal structures that people do. Creates a for-profit entity that gives you liability protection like you were a corporation. In other words, if I own a business that has 4 buildings on it and it's part of the LLC, and I go out and run over somebody in a car while I'm on alcohol or something, and I'm being sued for $4 million, they can only come for me. They can't attack the LLC. It's a separate entity. It's like another person, but it's not a person, if that makes sense. So that's a big advantage of it. And the interest in an LLC can also be moved through a will. It can be gifted, it can be sold during the life of an LLC. Typically, you need an operating agreement. The way most of these work is the LLC, 2 people, 4 people, 6 people, they will elect a manager and they'll let the manager manage, and the rest of them will sit back for the most part. That's called a limited liability corporation. As the name suggests, limiting your liability. You're creating another entity that's different than myself. So these are very good, and they do vary some state by state. Taxes are handled a lot like a partnership. S and C corporations. So a lot of people will couple an LLC with an S corp for their business, for their entity, because there's a lot of advantages, particularly to S corps. So generally, corporations are, well, I'm just gonna bounce ahead because I know very few people that get into C corps very much. I'm gonna bounce ahead and talk about S corps. And the beauty of S corps is that you avoid double taxation. So all the money you make through your S corp, you just record it as your normal earnings, right? Just like what I made from work or whatever. The entity itself doesn't pay business taxes, if that makes sense. So it's one tax, not 2. So that's the big advantage. Now, the problem with an S corp is it's limited usually to the number of people that can be in it, which is usually small, which is usually good in family and forest ownership, right? So it depends on the state, but it's usually 3, 4, 5 people. When you get above that, then you have to look at a regular corporation, and those are taxed as entities as well as your earnings as well. So S corps are great tools to avoid double taxation. They're even better when you join them with the liability protection of an LLC. Another form of ownership that are really complex, and the best way to describe them is they can be anything you want. They can be revocable, irrevocable, they can be specific, they can be general. So trusts, they cost more to produce. A will might cost $400 or $500. A trust might cost $1,000, $1,500, $2,000, depending on the complexity. But it's a way to transfer land. It's a way to even transfer business. It separates the management of an asset from the benefit of the asset, if that makes sense. So the grantor or settler creates the trust and its provisions. The trustee manages the trust and its assets per the provisions, whatever they are, and the beneficiary benefits from the trust. And it can be, to make it more confusing, it can be the same person, or it can be different people for one or both. So the takeaway is you can make these things do anything. So I've seen landowners that willed their land forward in a trust, and all of the assets went into an account, and the account was there for all their grandkids and great grandkids to borrow college money off of at a loan, 0% interest loan. And then they had to pay the trust back. So that's like grandfather speaking from the grave, right? So there's all kinds of things you can do to transfer assets through trusts. They're extremely flexible, probably the most flexible thing that you can use in estate planning. You have great freedom to develop why, how, and the discretionary power that the trustee has. And these can be done, trusts I can execute while I'm alive, a living trust, or I can execute after they can be executed after I'm dead, a testamentary trust. So the takeaway on trust is they're a little bit more expensive. You can build them to do virtually anything you want to. So sometimes it can be a little like bringing a gun to a knife fight. It can be too much. But if you have a lot of complexity in your estate, this is probably the way that you might want to go. So I mentioned that already, revocable and irrevocable trusts. I think I mentioned that. Revocable trust, I can amend it at any time. This is the way you can put your kids over the barrel. An irrevocable trust is I lay it out so it can't be tampered with without incredible problems. So there's just so many ways to structure a trust. Good tool, a little more expensive tool as well. So with that, I'm guessing everybody is tired of listening. And I'm going to kick it over to Becky, who's going to talk about some farm considerations and I think introduce some actual planning tools that you'll be able to access and download and take with you and share and use with your clients as well.
Thank you, Kurt. Great job. I think I really appreciated your talk about how thinking about the framing and the architecture. So, and again, just continue to remind folks that we're really trying to we're going to stay in our lane as extension agents and learn how to help people refer and get educated before they go see their these professional advisors. So remember too that learning takes repetition, and so sometimes we're really overwhelmed. We're hearing we just heard a lot of details and a lot of definitions, and they all kind of sound similar in some ways. But the more that you wade through it, the more comfortable that we'll get. So just a couple of things to kind of tie this up in a bow and give you some practical tools, worksheets that you can use to get started before you go see that attorney. So just real quickly, see if I can forward the slide somehow. Come on now. All right, so smaller farms, Kurt mentioned the S Corp, the C Corp. You want to pay attention likely to the C Corp. So some, the nature of smaller farms many times. Again, what Kurt said, that giving advice is we really can't do that because everything is so personal. So it absolutely does boil down to the particular situation that you are in. And that's why you go and see somebody that's an expert in doing this so that they can set you up to win. While medium and larger farms we typically see more LLCs due to the issues that medium and larger farms are going to be dealing with. Also machinery transfer. So those can be done in separate LLCs. So even thinking all about the details of machinery transfer, right? So there's a lot of property and different kinds of property and ways to do that. So be thinking about that. So a tool for income as well as transferring ownership is thinking about leasing your land. And so that might be an option if you're wanting to train, kind of give practice to that next generation, that junior generation, to give them some experience in management as well. So conservation easements, Kurt is going to talk really briefly about.
Yeah, I can walk through these. So yeah, conservation easements can be a great tool for people that as I kind of highlighted before, you may have a landowner that knows their kids aren't going to take their farm or forest and manage it in a way consistent with what they want. So a conservation easement will give you income. So the way that typically works is it depends on what the easement is for. But with land trust, you might sell my 1,000 acres of forest land to the state or to a land trust. In agreement, I might get 50–60% of market value. In return, I would give up my development rights. So easements are really nothing more than a bundle of rights. I can sell my mineral rights. I can sell my development rights, my water rights. As long as I have a willing seller and a willing buyer, I can match those up. So yeah, selling a conservation easement may keep my farm from being developed. And I may, while I'm alive, get 50% of market value, and I can still will it forward to my heirs, but it won't be developable. Oh, you want to keep rolling? Right. So yeah, so it's like a bundle of sticks. And I got this great slide here. If you're not familiar with easements or your property rights, really, you can sell anything to anybody. You can sell your water rights, which is not uncommon out west, for money. You can sell groundwater. You can sell mineral rights. I could sell on my 1,000 acres for the next 100 years. I could sell my rights for my timber to Weyerhaeuser if they want to buy it. And from now on, every 30 years, I know they're coming on my property. They're taking that. So all those rights are severable from my ownership. And you can sell those if you have a willing buyer and a willing seller. And this is very common. So this can be an option for a landowner to make income, certainly, like maybe I have minerals under the surface, or I have a lot of timber. But it could also be a way, if I found a conservation trust, I could sell my development rights and I could meet my goal of maybe never developing the farm or forest and also get income on this side of my life.
Thank you, Kurt. We have a couple of questions in the Q&A. We are going to have time for those. Let me finish up with thinking about before we visit our professional advisors. And having trouble clicking. Okay. Before we think about going to the professionals, we want to get our ducks in order so that we can reduce the bill. So the more organized and informed that we are, that's going to smooth out the process. So you want to assess your resources. Really think about the purpose of what you're wanting to do. That's going to be one of the very first questions that you're asked. What is the purpose? And given that, then there'll be pathways laid out to you. So you want to consider also your capabilities, the abilities of your heirs, setting your goals. Obviously, you're doing your homework. All of this is to help reduce those expenses. You're going to be gathering a lot of documents. There's going to be conversation and discussion that's needed, and you're going to want to continue to learn more and more about your options. As you're thinking about selecting an attorney, selecting your CPA, really the best way to do that, to find one, is very much like when we go shopping for other things. Comparison shop. Do you want to look for a good fit? Ask for referrals if somebody else has been satisfied. That's a really good indicator, right? You want to look for experience in this area. Not all attorneys know this, the area of real estate and trust. So you want to make sure that you are finding good advice. So we have for you a lot of worksheets, some of which you will use and some of which you may not, but these are all tools for you to get the conversation started and get yourself organized and informed. When I work with families doing this, it can be really overwhelming. Like people, you just sometimes hard to know where to start, how to start. So just know that, and know that there are tools and toolkits that can help kind of hold your hand through it. So here's a handout, and you will have after the webinar is over, there will be a link that's sent out that that connects you to the resources. So you have access to all that, so you can be looking for them. But estimating the value of your assets is one of them. And this is really important to know where documents are. A lot of times we even if we've done all this good work, but if our heirs and beneficiaries don't know where to find them, then what's it been for, right? So helping your heirs have like a toolkit so that they know what steps to take. So locating the documents is really important. I really like this handout, especially this emotional attachment scale. The research shows that people don't move forward in succession planning and estate planning a lot of times because it's a lack of communication. So some of these tools are really just exist to be able to help you start conversations. And in this, in our emotional attachment scale, it basically asks you to slow down and think about, why do I value this land or business? And so if you can start with yourself, then, and other people can be having that same reflection, and then you can come and communicate around it. I think it's really helpful to do this. When I work with families, sometimes some people are so connected to the business that it becomes their identity, and they will actually harm themselves for the business rather than understanding that the business is there to serve the person or the family. So you can get these dynamics in there that can be really complicated, because that is because we're people, complicated people. Another legal and financial instructions handout for you. Again, just like knowing where things are. There's several tools out there. This one that we have created for you is one of them, but we've got a few others we are highlighting because of the authors of this succession planning. We want to highlight the NC State has a comprehensive guide, as well as Purdue. And your own state could very well have a similar or comparable tool as well. So you could also check out that with your state extension. But you can absolutely pick and choose and use the resources across states as well. So whatever it is that's going to help you like make forward progress, that's what you want to focus on, because a lot of times we get really just stuck, and while we think, oh, this is a really good idea, doing it and executing it is really can be the sticking point. So we've got just a few minutes to open it up for questions. So Kurt, I want to ask you a couple of questions that are relevant to the material you presented on. And so first question, would the trust ownership be a living trust? Is the way that the question is framed, asked.
On audio. Yeah, I really have absolutely no way to answer that. So you can have a living trust, or you can have a trust that executes after you die. The choice is completely yours and is purpose driven. So I might have a trust while I'm living for different reasons, to control the management of my business and property. I may have one when I die. People that have special needs kids are often ones that want to have trusts. They don't want their child to inherit a lot of money because they won't know what to do with them, or kids that have an addiction. So they set it up in a trust, and the trust looks out for them either in this life or the next, so to speak. So the detail, the purpose is entirely up to you and your situation. So broken record, you really have to talk to your attorney. But the beauty of it, I think, is these tools that we showed you, these books, these workbooks that I encourage you to download. At least the one at NC State is more of a workbook. If you work through that, list your assets, my documents, when you hit the attorney's office, they're going to ask you for everything that's in that book. So if you show up and you give him that book, you've already eliminated 2 or 3 meetings with your attorney. They can just take that from you and be 99% of the way.
Excellent, thank you. Next question. Does the manager partner of an LLC receive extra compensation or a greater percentage of profits? If so, about how much?
Yeah, I hate to be a bummer. So it depends. So most of them that I know of, the ones that are running it are the ones that have an interest. So some of them, everything is divided equally because LLCs are really frequently are used to sort of not hide, protect physical property, right? So the physical property doesn't make money, the business makes money. So they're used to sort of protect that. So typically the manager is just the person that lives closest, is most skilled. But you could structure it any way you wanted to. If you wanted to write into your agreement, in compensation for me managing this LLC, whatever that consists of, I receive a higher share or extra money upon the sale or whatever. All those things can be created in an LLC. They're pretty flexible as well. And of course, the beauty of the LLC is to protect you from being sued and losing all your real property. It divorces my assets and protects my assets from being sued. Is really the beauty of the LLC. And it's cheap. It's only about usually $200 and a very easy reporting requirement to the Secretary of State in your state typically.
Thank you, Kurt. I think too, Monty, it is reasonable to, I think at the heart of this question is about the equity. So say that there is somebody that's on farm and they're managing it where you've got some siblings that are off farm, right? So then they've got all these interests all the overlapping, but there's more of this invested person. And so absolutely there are equity implications, and it is reasonable to value your time. But it can look all the different ways. They want us to talk more about how owning a percentage of an heir's property can force the sale of the remaining land is a question that we have. And I think we want to probably punt that to a different conversation. We're getting close up on time. Really, the heart of the answer of that is really about the UPHPA and if they're, where you're located. And the one other question, let's see, how to drill down to resources in your state. So certainly you can start with your extension, and you can even Google search your succession planning, estate planning in your state. And a lot of times that's in your ag economics, is housed there. Kurt, where are you? What's your unit?
Well, I'm kind of an odd one because I'm in Florida.
Okay. In
A lot
forestry,
of
yeah.
places have farm law centers. We
Mhm.
actually have a farm law center. Penn State does too. It's usually the real property division of the Bar Association that has all the attorneys that deal with this kind of stuff. So yeah, there's a lot of different resources depending on what you're looking for.
And
But you
Lamont, if
look at it in your state for sure.
Lamont, if you want to reach out, email us, we can help direct you and connect you. And Roseanne, we're going to throw it back to you so that you can help everybody and encourage them to take the evaluation, which really helps us.
Thank you all for attending today. We appreciate you and your time that you dedicate to serving your communities to make sure that we're impacting individuals and families, helping them continue their legacies and enhance their legacies through the process of succession planning.